All right. This is the matter of People's State of Michigan versus John Gallup, Circuit Court file number 25-6850-FH, set for arraignment on a bench warrant. You are Mr. Gallup, is that correct?
I am correct.
All right. Mr. Gallup, my name is Judge Hesselink. I'm sitting in today as a replacement for the circuit judge who's not available. We wanted to make sure that you got arraigned in a timely manner, so that's why I'm sitting in for today's purposes. The allegation against you is that you failed to appear on for a hearing in the circuit court on June the 11th at 10:30 for a circuit court jury status conference. That could result in a change in your or additional bond, and it could also result in a contempt of court. Contempt of court has a maximum penalty of $7,500 fine and a 93-day amount of time in jail. That's not to say that that's what the judge will do, but that's what the judge could do. If you wish to have a contested hearing as to that, you could have a hearing in front of the judge. You do not have the right to have a jury trial. You could see, hear, and question all the witnesses. Well, you do not have the right to have a jury trial on a condition of bond like this. You have the right to have a hearing in front of a judge. At that hearing, you have the right to see, hear, and question the witnesses. You can present your own witnesses and get a subpoena or an order from the court requiring witnesses to appear and testify. You could testify or you could remain silent. You'd have the right to have the burden of proof beyond the probation department to prove that you failed to appear, and you'd have to have the right to appeal. You have an attorney already on this matter?
Yes, Your Honor.
All right. Mr. Brown could also represent you at that hearing on the failure to appear. Typically what gets done is we give you some time to consult with your attorney. We reset bond, and then we continue with the next court hearing, and the judge would then address both of those at the same time at the next court hearing. Mr. Brown, are you asking for anything else to be done in this particular case?
Just to address bond, Your Honor.
All right. Mr. Gallup, I'm going to allow both the attorneys to address bond with me, and then I'm going to give you an opportunity to address bond as well. So, Mr. Fortier, your thoughts on bond?
Judge, what was the bond he had that he was already out on? Was it $2,000?
That was what it was when it left the district court. I don't know if it was changed in the circuit court. Mr. Brown, are you aware of that? Or Ms. Anderson, do you know what the current state of the bond is?
It was $2,000 is what we had.
All right, thank you. It appears it was the bond was at $2,000 previously. Mr. Fortier, any other comments?
I usually would ask to double, but that's kind of low still. So at this point, I'm going to ask for $10,000 cash or surety based on his failure to appear. It was back in June, and here we are now at the end of August. So I think that $10,000 cash or surety would be enough to ensure his
Thank you,
appearance.
Mr. Fortier. Mr. Gallup, I am going to give you an opportunity to comment, but I can't have you talking over everybody else. We don't get a clear record that way.
Okay.
So you're just going to have to restrain yourself until you get an opportunity, and I will give you an opportunity to speak. Mr. Brown, your comments?
Your Honor, the court hearing, I remember the court hearing.
Mr. Gallup, step over here. Either be quiet or we're going to mute you.
I'm sorry, I was talking to the officer over here. He was speaking to me.
I don't need to hear anybody saying anything until it's their turn to talk. So just keep it quiet.
Okay.
This is Mr. Brown's turn to chat, and then I'll give you an opportunity. Mr. Brown, go ahead.
Your Honor, I do remember this. I am reviewing my notes on this particular matter. There was a hearing scheduled back on June 11th at, I believe, 10:30. Mr. Gallup did advise me. I received a text at 10:55. I did not read it until later because I was still in court, that he was having technical difficulties and that he could not log on. I believe that he may have eventually logged on. However, I brought the matter up again before the judge that afternoon to see if we could hear the matter. He denied that request and let the bench warrant stand. So this was a technical difficulty. He actually did end up appearing but the judge in the circuit court would not rescind the bench order. So I believe that he would show up.
All right. Mr. Gallup, you also have the right to address me as to bond. I simply would caution you not to make any statements as to the facts of the underlying case because we are recording this and it may be used against you. But if there's any information that you wish to talk to me about the bond itself, I'd be happy to listen. I'm sorry. Go ahead, sir.
I'm sorry, sir, that I didn't do anything wrong. I did show up. It was a server error, is what it came up as. It said server error. And I sat there for 2 hours on the hearing, and now I get to double my bond, and I don't have any money. So I don't get to pay my child support on 3 kids. I don't get to pay my court fines. I don't get to pay my rent. I don't get to pay my phone bill. So now I'm going to be just here with you in court, in jail. And I would like to file a misrepresentation charge on Larry Brown Jr. because he didn't
Mr.
file
Gallup,
for
Mr.
another
Gallup,
hearing.
that's got nothing to do with bond.
I don't want him as a lawyer. I don't believe it.
Excuse me, please.
I just think
Mr. Gallup, nobody can hear you right now, so you're going to have to calm yourself down so we can talk to each other. If you will calm yourself down, I'd be happy to hear from you, but it has to be about bond, not everything in the world that you're mad about. You understand me? Mr. Gallup, if you're not going to be calm, I'm not going to let you talk. Are you going to be calm so I can chat with you or not? All right, turn him back on so we can chat with him, please.
The jail might have to accept it. That's to unmute.
Yeah, Deputy, I believe that you're going to have to accept our request so we can turn him back on.
There you go, Your Honor.
All right, Mr. Gallup, as long as you remain calm, I'll let you talk. But if you're going to get angry with me, I'm simply going to turn you off. You understand? Now, is there something that you want to tell me about your bond in addition to what you said already? All right. Mr. Gallup's bond was $2,000. Previously, it appears through his attorney that he did try to appear. So I'm simply going to reinstate his bond at $2,000, cash or surety, 10%. You're going to owe $200 to get out of jail. Mr. Gallup, that was your original bond. Next time you appear before the court, it would behoove you to act appropriately because you got pretty close to the line where I'm going to say, just because you're out of control, I was going to raise your bond. But if you will keep your head, things will go all right for you. Do you understand, sir? All right.
Yeah.
Your bond is reinstated at $2,000 cash, surety, or 10%. That's all for today. Thank you.
Hello.
Good afternoon.
Good afternoon. How are you?
I am good. You want to just hold out on for a minute? We'll get the cases started in just a minute as I finish up my paperwork from what we were just doing.
Thank you.
All right, we have 2 matters. First is State of Michigan versus Samantha Lewis Millard, file 25-43682-ST. And then we have another case with Ms. Millard. That's file State of Michigan versus Samantha Lewis Millard, file 24-43338-SM. I do see Ms. Lewis Millard is with us. Ma'am, do you have an attorney?
No, I don't.
Do you wish to have an attorney? I'm sorry, I did not hear anything that you said, ma'am. Do you wish to have an attorney?
No, and I think we can settle out of court. Or out without attorney.
All right, ma'am, I'm catching about every other word that you're saying, so you're gonna have to get closer to your phone and speak a little more slowly.
I think we go without an attorney.
I'm still only catching about half of what you're saying.
I think we can schedule it without an attorney.
All right. Thank
No
you. I heard you that time. All right. If in the
Okay.
future you wish to, if in the future you wish to change your mind, you can certainly do that, but we'll proceed today without an attorney. We are set for a status conference, which means a decision about what you want to do with the case. Mr. Fortier, has there been an offer made in these matters?
There has. It's plead to one, dismiss the other.
Does it matter to you which one is which?
No.
All right. I believe these are both driver license suspended.
Right.
Mr. Fortier, one of these tickets has a second offense notice on it. Is it your
That would be
understanding?
dismissed.
All right, so we'll dismiss that. So the offer is plead to one count of driving license suspended, dismiss the second offense notice, and dismiss the other file completely. Is that accurate?
Correct.
All right. Ms. Lewis Millard, would you like to do that, or do you need some additional
Yes.
time to consider that?
Nope. I'll do it.
All right.
Judge, it looks like it'd be easier if she pleads to the 24-4-3-338 case, and then the 43682 case would be dismissed.
All right. I do not see a clean action sheet. Print me one. I'm missing some paperwork, so if you just hang on for a minute while we get that taken care of, then I can proceed on these cases. Actually, print me two, dude. All right. Ms. Lewis Millard, while we're waiting for that paperwork, there's some rights that I need to advise you of so that you understand them before you can say that you want to waive them. In both of these cases, because they are criminal offenses, you have the right to have a trial by a judge or by a jury. At trial, you'd have the right to see, hear, and question the witnesses. If you wanted to have an attorney represent you, an attorney could represent you at that trial. You'd also have the right to present your own witnesses in your own defense. And get an order from the court called a subpoena to require witnesses to appear and testify on your behalf. You'd also have the right at a trial to testify yourself, or you could remain silent, and that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal automatically. However, if you enter a plea in the future, you'd only have the right to ask the court for permission to appeal, and that might be denied. You understand all of those rights that I've just explained to you?
Yes, sir.
Do you have any questions about any of those rights?
No, sir.
All right. Knowing all of those rights, is it still your desire to enter a plea today pursuant to this agreement with the prosecutor?
Yes, sir.
All right. Let me catch up with my paperwork here for just a minute.
Mm-hmm.
All right. In order to take a plea from you, I have to get some testimony from you. So would you raise your right hand, please? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Correct. Yes.
All right. Has anybody promised you anything other than this plea agreement in order to get you to plead today?
No.
You can put your hand down, ma'am. You don't have to keep it up. Has anybody threatened you in any way in order to get you to plead today?
No.
Are you doing this of your own free choice and free will?
Yes.
All right. The charge against you in file 24-43338 says that on or about December the 15th of 2024 in Bagley Township of Otsego County that you did drive with your license suspended on Kasuba Road near East M32. Is that true?
Correct.
Do you remember what vehicle you were driving at that time?
2020 Dodge Charger.
And do you know why your license was suspended at that time?
It's fines. I pay my fines.
All right. Mr. Fortier, any additional questions as to a factual basis?
No, Your Honor.
All right. Are you aware of any other promises, threats, or inducements not stated on the record?
I am not, Your Honor.
You believe I've complied with the court rule?
You have, Your Honor.
All right. Ms. Lewis Millard, are you asking me to find you guilty of this offense because you are in fact guilty?
Yes.
All right. I will accept your plea. I do find that it was knowingly, intelligently, and voluntarily made. You have given me a proper factual basis and that you've admitted on December the 15th of last year that you drove with your license suspended on a public highway within Otsego County, being Kasuba Road in Bagley Township. So I will accept your plea. And I'll ask the prosecutor to file a dismissal form called a nollie in the other file as per the agreement. Ms. Lewis Millard, do you wish to proceed directly to sentencing today?
Yeah, we can.
All right. Mr. Fortier, any issues with that?
No, Your Honor.
All right. Ms. Lewis Millard, I'm going to ask the prosecutor for his comments as to what he thinks an appropriate sentence would be, and then I'm going to give you that same opportunity. Mr. Fortier, what do you think? What would you ask me to do?
Judge, I would ask that the court just issue fines or order fines and costs.
All right. Ms. Lewis Millard, any additional statements that you want to make as to sentencing?
No, thank you.
All right. I am going to accept the prosecutor's request. There's a $75 crime victim fee, $50 justice assessment, court costs of $100, local costs of $15, and a fine of $75. A total of $315. How long do you think that you'll need to pay that off, ma'am?
You can set up a payment arrangement. Probably like 6-7 months because I have other cases that I'm paying on too.
All right. If you're going to do that, then I'm going to have to put you on probation and have you pay it over the course of your probation.
And how long would I need to pay it off? Not have probation.
I'm not able to hear what you're saying when you talk that fast.
How long would I have to? How soon would I have to pay it off not to have probation?
30 days.
How much was it? 300?
315.
I can pay it off.
All right. I'll just say pay within 30 days. If you don't pay within 30 days, then we'll probably have another hearing and put you on probation at that point.
Okay.
All right. Do you have any other questions?
Nope, that's it.
All right. That'll be the order of the court then. Thank you.
Thank you.
All right. The next matter is the state of Michigan versus Ricky Bear. It's file 25-43738-ST set for a status conference.
Yes, James Dick on behalf of Mr. Bear. Mr. Bear is here on Zoom, Your Honor.
I do see Mr. Bear on Zoom. This is set for a status conference. Do we have a resolution of this matter?
Yes, we do, Your Honor. Mr. Bear will be entering a plea to allowing an unlicensed driver to operate his vehicle in exchange for a dismissal of the original charge.
Mr. Fortier, is that an accurate statement of the agreement?
It is, Your Honor.
All right, Mr. Bear, you've heard what the attorneys have said. Is that what you want to do?
Yes, sir. Yes, Your Honor.
All right. It's my understanding that the offense that would be dismissed would be no operator's license or multiple licenses. That's generally referred to as no ops. That's a misdemeanor offense. And that you would be pleading to allowing an unlicensed person to operate a vehicle. That's also a misdemeanor offense, but typically it just has fines and costs attached to it. And in addition to that, it's not reported to the Secretary of State, so it doesn't go on your driving record. Understanding all of that, is that what you want to do today?
Yes, sir. Yes, Your Honor.
All right. There are certain rights that you have right now that you'd be giving up in order to take that agreement. So I want to make sure that you understand those. So let me tell you what they are. You would originally have the right to have a trial by a judge or by a jury. You could have Mr. Dick continue to represent you at that trial. You could see, hear, and question all the witnesses at trial. You'd have the right to present your own witnesses and evidence and get an order from the court requiring those witnesses to appear and testify. You could also testify, or you could remain silent. And if you chose to remain silent, that silence could not be used against you. In addition, at the trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. And that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. However, if you enter a plea, you're limited to asking the court for permission to appeal, and that might not be granted. Do you understand all of those rights?
Yes, sir.
Do you have any questions as to any of those rights?
No, sir.
Knowing all of that, do you still intend to enter a guilty plea today?
Yes, sir.
All right. I need to take some testimony from you, so would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Thank you. You can put your hand down now. Has anybody promised you anything other than this plea agreement to get you to plead guilty today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, sir.
All right. The amended charge of allowing an unauthorized person to operate a vehicle would read as follows. It would say that on or about May 13th of 2025, within the city of Gaylord and Otsego County, that you did allow an unauthorized person to operate a vehicle upon the Iron Bell Trail near the Lake State Railway. Is that true?
Correct.
Can you tell me what vehicle was being used at that date and time?
A 2020 Chevy Sonic.
And what was the reason that you or the person that was operating did not have a valid license?
My license was suspended out of North Carolina. I did not, was not made aware of it because
All right.
I've been up here for a couple of years.
All right. So you found out that your license was suspended and then the police wrote you a ticket for it, right?
Correct.
All right. Either attorney have any other additional factual basis questions?
No, Your Honor.
No, Your Honor. Thank you.
Either attorney aware of any other promises, threats, or inducements not stated on the record?
No.
None.
And have I complied with the court rule?
You have, Your Honor.
Yes, you have.
All right. I will accept the accept the plea. I do find that it was knowingly, intelligently, and voluntarily given to me based on the answers to the questions. And then I also find that Mr. Bear has given me a proper factual basis and that he admitted on May 13th of 2025 to operating as an unlicensed, unauthorized person because of his license being suspended within Otsego County on a public highway, that being the Iron Bell Trail, or an area open to the public operation of vehicles. So I will accept that plea. Is there any reason why we should not proceed directly to sentencing?
No.
No, we would request that the court does so.
All right, Mr. Bear, I'm going to ask each of the lawyers to tell me their thoughts as to sentencing, and then I'm going to give you the same opportunity to address me. So we'll start with the prosecutor, Mr. Portier.
Judge, I just ask that the court order fines and costs.
All right. Mr. Dick, your allocution?
Likewise, we would request that the court just issue fines and costs, and Mr. Bear does currently have a license again. As you mentioned, he wasn't aware of the suspension until he was stopped. Once he became aware of that, he did clear it up and was able to obtain his license again.
All right. Mr. Bear, is there anything else that you want me to be aware of that hasn't been stated already?
No, sir.
All right. The court will, as it typically does in these cases, apply fines and costs only of $290. Can you pay that within the next 30 days, sir?
I should be able to pay at least part of it within the next 30 days. I might need to ask for an extension to 60.
All right. I'm going to say pay it within 30 days and try to do that. If you have to ask for an extension, sometimes I have to put you on probation and there's an extra cost for that. And I don't really want to do that up front. So let's see what you can get done. I don't want to tell you to beg, borrow, and steal it from somebody else, but that might be a great idea to get it taken care of here and then pay somebody else back later if you need an additional amount of time. Any questions that you have, sir?
No, sir.
Mr. Dick or Mr. Fortier, any other questions?
Actually, I'm sorry. I have one question. Where do I go to pay that? Do I just go to the courthouse or?
I'm going to give you a phone number that you can call and take care of that. All right.
Okay.
That's, do you have something to write with?
Give me just a second. I do now.
989-731-0201.
989-731-0201.
That's it.
All right.
Thank you. That's all for today, sir.
Thank you. Yeah, have a nice day.
Yeah.
All right. The next matter we have is State of Michigan versus Nathan Curley, file 25-43827-SM, set for a status conference.
James Dick on behalf of Mr. Curley. Mr. Curley, please turn on your camera. There we go.
All right. I do see Mr. Curley now. This is set for a status conference. Mr. Dick, do we have a resolution of this matter?
Yes, we do, Your Honor. Mr. Curley will be pleading guilty to the retail fraud second. And yes, the prosecutor was not advocating for jail time in this matter.
Is that an accurate statement of the agreement, Mr. Fortier?
It is, Your Honor. There's also a restitution amount of $371.20 to Walmart.
Correct.
All right. Mr. Curley, you've heard what the attorneys have said. Is that what you want to do?
Yes, Your Honor.
All right. The original charge was retail fraud in the second degree. So the prosecutor is asking that you plead as charged to that. That is a misdemeanor offense. It has a maximum penalty of 1 year and or I believe a $2,000 fine. In exchange for that, the prosecutor is not going to recommend any jail in this particular case. Is that your understanding of the deal?
Yes, Your Honor, it is.
All right. In order to take that deal, you'd have to give up what are known as your trial rights. So let me tell you what those rights are so that you can make an informed decision. You have the right to have a trial by a judge or by a jury. You'd have the right to have your attorney, Mr. Dick, continue to represent you at that trial. At trial, you'd be able to see, hear, and question all the witnesses. You'd be able to present witnesses and evidence on your own and get an order from the court requiring your witnesses to appear and testify. You could also testify yourself, or you could remain silent, and that silence could not be used against you. You'd also have the right to be presumed innocent until proven guilty beyond a reasonable doubt, and to have that burden of proof remain with the prosecutor at all times. Finally, at a trial, you'd be able to appeal automatically any error at that trial. However, if you enter a plea, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you understand the rights that I've just given to you?
Yes, I do, Your Honor.
Do you have any questions about any of those rights?
I do not, Your Honor.
All right. Knowing all of that, do you still wish to enter a plea today?
Yes, I do, Your Honor.
All right. I need to take some testimony from you. So would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right. You can put your hand down, sir. Has anybody promised you anything other than this plea agreement to get you to plead today?
No, sir.
Has anybody threatened you in any way to get you to plead today?
No, sir.
Are you doing this of your own free choice and free will?
Yes, I am, Your Honor.
All right. The charge against you reads as follows. It says that on or about June 16th of 2025, within the city of Gaylord and Otsego County at the Walmart located at 950 Edelweiss Village Parkway, that you did commit the act of retail fraud in the second degree, in that you did, while the store was open to the public, steal property that was offered for sale there of a value over $200 but less than $1,000. Is that what you did?
Yes, Your Honor.
Can you tell me what it is that you stole from the Walmart store?
Yes, Your Honor. I'm ashamed to say it, but the items were basic household items. Some disinfectant, cleaner, antibacterial, laundry detergent pods, and girls' sandals.
All right. You believe that those added up to more than $200?
No, there was other items that were included on behalf of Walmart from previous times on different dates that I am aware of. Obviously, just not.
All right. So all within a year's period of time.
I'd say with
All right.
a couple months.
All right. Thank you. Any additional factual basis questions from either of the attorneys?
No, Your Honor.
No, Your Honor.
Either attorney aware of any other promises, threats, or inducements not stated on the record?
No.
No, Your Honor.
Do both attorneys believe that I've complied with the plea taking court rule?
You have, Your Honor.
Yes.
All right. I will accept the plea entered by Mr. Curley. I do find it was knowingly, intelligently, and voluntarily given. He did admit the elements of retail fraud in the second degree, indicating that he stole items offered for sale while Walmart was open to the public, and that was the Walmart that was here in Otsego County. That the value was over $200 in total from all of his thefts from Walmart. So I do believe that that was a proper plea, and will accept it. All right. Is there any reason not to proceed directly to sentencing?
No, Your Honor. I don't believe so.
There's not.
All right, Mr. Curley, what I'm going to do for sentencing is I'm going to give each of the attorneys an opportunity to tell me what they think a proper sentence would be. And then I'm also going to give you an opportunity to address me at the end so that you can hear what they have to say first. Mr. Portier, go ahead.
Your Honor, naturally here, the most important thing that we're concerned about is the restitution to Walmart, which I've already given to the court. So outside of that, I would leave any sentence up to the court. Would state that I did indicate to Mr. Dick that I would not be advocating for upfront jails. I don't think that's necessary at this point. Just the main thing is just that the restitution gets paid.
All right, thank you. Mr. Dick, allocution?
Yes, Your Honor. Mr. Curley, he's a 36-year-old father of two. This incident occurred around the time of the ice storms and whatnot. Mr. Curley believed he was only doing what he needed to provide for his family, as can be recognized by the items that were taken, specifically cleaning items, clothing items, basic necessities. Mr. Curley, he does feel horrible for this. He's rather embarrassed. Since he was having those hard times, he's been able to get back into work. He does drive up north for work each day. He just finally really started picking up and being busier and making enough money to support him and his family since this summer. He really didn't have any other work this earlier this year. With his two young children at home and his wife, he was the only one working. He is taking full accountability and responsibility for his actions here. And he does acknowledge the restitution and intends to pay that back. He doesn't have any recent significant criminal history. I believe most of what he had was when he was younger, more than 10 years ago. However, he may have an OWI from a number of years back as his most recent offense. he has, since that, he's been sober and really focused on his family and whatnot for about 6 years. With that, Your Honor, we just ask that the court takes into consideration this was not done as a malicious thing. It wasn't done for personal gain. It was done as a means of survival. And while we all recognize that there are other ways that this could have been handled, unfortunately, at that time, he did what he did, thinking that he didn't have another choice. We would just ask that the court assesses minimal fines and costs in this. And of course, we understand that there's likely a short period of probation as well.
Mr. Curley, you also have the right to address me as to anything that you think that I should be aware of about you. This is your opportunity, sir. Go ahead.
Yes, Your Honor. Mr. Dick pretty much stated everything. Essentially, that I'd want to say. I am really ashamed and, definitely embarrassed. Unfortunately, it's what it is, and I made those choices, and obviously there's consequences. I just wanted to apologize, I guess, essentially to Walmart or anybody that had to deal with it. The courts as well. All I can do is just move forward and obviously make better choices. But beyond that, like I said, Mr. Dick pretty much stated everything, and I just obviously want to move forward and, get back to life. I'm sorry, that's all I have to say, Your Honor.
Thank you,
My
sir.
apologies.
No, you're all right. I'm just looking at some materials here I'm going to ask you about in just a second.
Okay, yeah.
Mr. Curley, I'm looking at your criminal history. This is the first time that I've seen it. So I want to make sure that it's accurate. You have a prior conviction for false pretenses between 200 and 1,000 out of the 65A District Court in May of 2010.
That is Clinton County.
Yes.
Yeah. It actually was my mother's debit card. I had taken it.
You don't need to tell me. Go ahead. Go ahead.
My apologies.
No, that's all right. Go ahead.
I had taken her debit card, I'd already had it, but I didn't give it back, and made some purchases with it. And those were the circumstances of that. And she called and reported it.
All right. Do you also have a conviction out of the Shiawassee County Circuit Court in December of 2010 for home invasion, 3rd degree felony offense?
That's correct, Your Honor.
You also have a home invasion, 2nd degree in October of 2015 in the Saginaw Circuit Court?
That's correct, Your Honor.
You also have a misdemeanor attempted retail fraud, 3rd degree out of the Shiawassee District Court in February of 2012?
I recall, Your Honor.
You also have a conviction for financial transaction device stealing or retaining in August of 2015 in the Otsego County Circuit Court?
Yes, Your Honor. That was old girlfriend.
That also included a retail fraud, 3rd, went along with that financial transaction device?
Yes, Your Honor.
And then in January of 2020, in the 87th District Court for Otsego County, conviction for retail fraud, 3rd degree?
I'm sorry, what you said?
January 30th of 2020 in this court, conviction for retail fraud in 3rd degree.
Oh, Yep, I do from Walmart.
All right. And then June 11th of 2020, another retail fraud second degree in this same court.
I honestly, I don't recall. I don't recall that one, Your Honor. I know there was an incident. This is before I got sober when I was still drinking. And most, if not all of these are attributed to choices I was making when I was drinking, of course, which doesn't excuse anything. But I had started drinking a bottle of wine inside the store and I left with it. It was, I think, the circumstances of that. And, I mean, I was intoxicated and vaguely remember most of it, but yeah, drinking was a huge problem for me.
What have you done since then? What have you done since then about that?
I've been sober 6 years from alcohol. I did have the driving impaired 2020 22 21 21.
This says March. You were arrested in March of 23 and pled sentenced in October of 23.
Yes, I had taken too much medication, pharmaceutical, for anxiety, and I had got in a confrontation with a tow truck driver during some bad weather. I was stuck in the ditch, and unfortunately, that led to police obviously worried about my ability to drive. And I told them. Beyond that, I mean, I've definitely made some poor choices, Your Honor. The home invasions, all people I knew, family, old girlfriend, and just went about things the wrong way and made some bad choices. I lived kind of a rough lifestyle growing up, and I'm originally from downstate in the Flint-Owasso area, Shiawassee, Genesee County. I like I said, made some bad, poor choices when I was really young, and didn't really understand the severity of it until, it catches up with you and it follows you, and another bad choice will only make it worse. The last thing I want to be involved in is the courts and anything like that, and I thought those days were over, and I've really got to make the right choices. I really got to just, I know right from wrong. I know what is and what isn't. Like I said, Your Honor, I just want to move forward and just hopefully move past this and get on to better things.
Mr. Dick, is there anything else that you want to say on your client's behalf?
Well, Your Honor, just I know he acknowledges the fact that he has the previous charges and whatnot, or convictions and whatnot. I just do want to reiterate that they are, for the most part, they're a little bit older. He's been keeping his nose clean aside from that OWI for the most part. That being said, no, I don't have anything else, Your Honor. Thank you.
All right. Thank you. I'm not going to follow the prosecutor's recommendation in this case. Even euphemistically, Mr. Curley has not kept his nose clean. He's had 15 straight years of involvement with the court system. He has multiple misdemeanors for the exact same charge that he's done this time. Tells me that in the past it was alcohol or drugs that caused him to do it. But apparently now that he's clean, he's back doing the same thing before. This was not a mistake. This is a very clear pattern of behavior. Whenever, for whatever reason, he gets short on cash, he goes to his local Walmart and makes a withdrawal. And that's illegal behavior. And he's been in jail and out of jail and done felonies and done misdemeanors, been on probation and not been on probation. And there's a clear pattern of behavior. I can't just look the other way. I can't just say, well, today's a new day and it's okay. We'll just treat you as a first offender. He's not even a fourth or fifth offender. He's got 8 or 9 of these things. My counting might be a little bit off, but not much. And he hasn't gone more than 3 or 4 years without getting another conviction. Been in prison. He's been in jail. He's been on probation. I'm sorry, but when we started talking, this sounded to me like it was a first offense, maybe a mild second offense, and that was the reason for the plea offer. But that's not the case. So he's going to be on probation for 720 days. That's the most I can give him because I need to have a handle on him. There's going to be a $75 crime victim fee, $371.20 in restitution, $50 justice assessment. There's a $400 court cost, $200 fine, $15 local fee. Let me add that up for you as a fines and costs. The total of, with the restitution amount, is total of $1,111.20. Pay that over probation. You may work some of that off by a community service, but some of that's going to have to be paid in person because you can't work all of it off. I'm going to require him to enroll in an economics crime course. That's a series of videos that he'll have to talk with probation about. While he's on probation, he's not to consume or possess alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means no bars. You can go into a restaurant that happens to serve alcohol, but you may not go into a bar that happens to serve food. Drug testing is ordered by the probation or the drug line. May not enter Walmart. And you must do 60 days in jail. 60 days forthwith here at the Otsego County Jail today at 6 p.m.
Yeah, I'm going to lose everything.
That's your own fault, sir.
Your Honor, I need this job.
What you need to do is stop stealing from your community.
I know, Your Honor. I take full accountability, but if I go to jail, I'm seriously going to lose
everything. This is
everything.
part of that full accountability, sir. 60 days in jail is not the most that I could give you. You're lucky I only did that.
My wife just had surgery, Your Honor.
You don't appear at the jail today at 6 p.m. We'll send officers looking for you after we issue a bench warrant. That's all for today, sir.
Oh, man.
Give him, please. Next case is State of Michigan versus Jonathan Bowers. File 25-43858-SM. Set for sentencing.
Hearing the stick on behalf of Mr. Bowers. Mr. Bowers is appearing by Zoom, Your Honor.
All right, I do see Mr. Bowers is with us. This was a domestic violence plea with a 769.4A delay of sentence status. And we adjourned it to today's date, I assume, for the victim's information. Mr. Portier, do we have any additional victims information?
It appears that the victim wanted to speak. I think Ms. Weber from my office might have a little more input, though.
I believe Emma Murphy is the victim, and I do see her in the
Yes.
courtroom.
All right, Ms. Murphy, are you present with us?
Yes, Your Honor, I'm here.
All right, thank you. You have the right to speak at sentencing and to tell me what it is that you want me to know about this case. So I'm happy to listen to you now if you'd like to go ahead.
Yes, Your Honor. Honestly, I never really wanted any of this to happen. I didn't make the phone call to the police in the first place. It was just a misunderstanding that got out of hand, and I miss him a lot, honestly. His son misses him. I mean, the dogs even are not acting the same without him around. Life is hard, harder than it used to be, and I've been, trying to just think of ways to explain how, I wish none of this happened. I feel really bad, and I want to work things out, and I wish that, like I said, none of this even happened in the first place. But yeah, I mean, that's really about it, Your Honor.
How long have the two of you been together?
We've been together about 5 years.
Okay. Do you believe that the two of you need any sort of counseling to make sure that this doesn't continue to be an issue?
I mean, I wouldn't be upset if he got some kind of therapy, but I don't think it needs to be like court ordered.
How do I make sure that this doesn't happen again?
I would like to just say that, it was mostly just due to his drinking. And when he doesn't drink, he's a wonderful partner. He's a great dad. He's a good friend. He goes to work. He does what he's supposed to. I guess as long as he stays away from the alcohol, everything should be fine.
Why do you think that he does that when he drinks? What is it about him and alcohol that causes that?
I feel like he might have some trauma, some things that happened to him in the past where he gets angry when he drinks, and I feel really bad for him, honestly. I wish that he was, healthy and could enjoy life and be happy without alcohol.
All right. My experience in the past, I work with the recovery court here in Otsego County, and I've been a lawyer for a long time with prosecution and defense. So my experience with alcohol in the past has been that it takes away your inhibitions. It takes away that part of you that stops what is already inside of you. If you got a bad thought in your head and you don't drink alcohol, you can stop it, but the alcohol takes away that gatekeeping function, and that whatever is inside tends to come out, which leads me to believe that most people who act as angry when they've been drinking have anger inside of them already. It sounds to me like you think that that's true as well, and he might need some assistance with that. Would that be accurate?
Yeah, I don't think it would hurt.
All right. Is there anything else that you want me to know, Ms. Murphy?
No, not really, Your Honor. I just hope that, you could see that this wasn't something that, was supposed to happen in the first place. Even really, it was, like I said, just a misunderstanding that got out of hand.
And you're asking that he be allowed to have contact with you immediately. Is that correct?
I would appreciate that. I'm sorry.
That's all right. I
Like
understand.
you said, I miss him. His son misses him. I feel like I'm not even, I'm not happy without him here. Even though we did have that one incident, life is very hard without him.
And I can certainly understand that. I just don't want life to be hard with him as well. And that's my concern, that if it happened once, it may happen again. And then we've got an even bigger problem, both for you and for the court system.
Yeah, I understand completely. And that's what I was thinking. Maybe, some type of therapy or counseling or something maybe along those lines wouldn't be a terrible idea.
Okay. All right. Anything else that you want me to be aware of?
No, Your Honor, that's it. Thank you for listening.
All right. I appreciate you being here, and I know this is difficult for you to do, so thank you very much for your time. All right, Mr. Bowers, I'm going to give the attorneys also an opportunity to address me now. I'm going to start with the prosecutor and then your attorney, and then I'll turn to you so you have the ability to hear everybody and can respond after that. All right, sir? Mr. Fortier, your thoughts?
Judge qualifies for deferral, and I believe that's the offer that was made. So I would just ask the judge to, I would just ask the court to follow that.
All right. Mr. Dick, your allocution?
Yes, Your Honor. So Mr. Bowers, he's a 30-year-old father. Him and Miss Murphy have one child together. He has been attending AA. He's only gotten a couple sessions in thus far. However, it's my understanding that he does intend to continue with this. He was trying to find a location to attend previously when he was up north farther. He was just having some trouble finding the actual locations because he wanted to be somewhere physical so he could physically interact with others. Mr. Bowers, he's been kind of finding himself a little bit since this incident as well. He does take ownership for drinking and how he acted. He did, however, find himself for a short period in sober living up in Petoskey. He did also end up, I believe, camping for a little bit, working on himself, all while continuing to work because he was still sending money home to take care of his, Miss Murphy and their child. This particular incident, it was surrounded by an argument and a couple people pushing on the door and yelling, and ultimately, Mr. Bowers here did admit that he did push Miss Murphy. He is currently working. He's back here in Gaylord. He's working full-time, and he is currently residing with his mother, who lives also in Gaylord. He is able, he did want to make sure it was known that he can pay for any testing that the court would require. And he's willing to do any sort of counseling, anything else that the court would deem necessary to allow him to ultimately return home to his family, which is Miss Murphy and their child. With that, Your Honor, we would just ask that the court affords 769.4A and a reasonable term of probation, and also fines and costs in some sort of a reasonable manner. But
all right,
that's all.
Thank you, Mr. Dick. Mr. Bowers, is there anything that you want to tell me specifically?
Getting back to my son is the biggest thing. Being able to be a family with Ems and Dimitri is everything to me. Making sure they're safe and both tucked in at night. I would just really appreciate to make sure I have that opportunity. And, I understand your concerns and your fears. And I can assure you that I'm not going to be fighting with her. I'm not going to be drinking. I know that what I've done was wrong. I know that I have placed my family, in a bit of a situation with my own actions. And things have been made stressful upon my child. and I'm the one to blame for that. Like, he needs his father, and his father made actions and decisions and choices that led to him not being there. And if there is one person that's been hurt by this the most, it's definitely my son, and that is 100% on me, sir.
Well, I appreciate those thoughts, and I'm glad to hear them from you, because it tells me that you've been spending some time thinking about what happened and what caused this and how you can fix it. So I'm pleased to hear that you are at least in the thinking stage of doing things about it. It also sounds to me like you have been doing some actual actions as well. Your attorney mentioned sober living, AA, those sorts of things. And the fact that you've been supporting your family while you've been away from the home also tells me that you're trying to do the right thing. So for that reason, I am going to give you the opportunity to show me that you can do the right thing. And I'm going to go relatively easy on you. I'm not going to hold your feet to the fire as much as I could under other circumstances. So I am going to give you 769.4A. What that means is that if you successfully complete this probationary term, you won't have a criminal record as to this, and the case will be dismissed against you. However, if you don't successfully complete this, then you will have that on your record. And if there's any violations of the court's probation, you could be brought back in and sentenced to an additional penalty for that. So that's how that process works. But I think you've earned the initial carrot, if you will, of having this available to you so that you can keep it off your record and it doesn't hurt you in the future. In addition, I found the statement from from the victim in this case to be heartfelt, from Ms. Murphy to be heartfelt and to be well thought out. She indicates that she misses you, but she also recognizes that you've got some work to do. So she's not just minimizing things. I think she's looking at things straightforwardly, and you would do well to listen to her counsel in the future if there's any issues that come up. And I would encourage her to speak to you directly and say, hey, don't start down this path again, because this is what led you to the problems in the past. All right. So I am going to give you an opportunity to be with your family immediately. I'm not going to keep you away from them now, but that comes with you doing what you're supposed to be doing. And so I'm going to give you some things to do while that's occurring. All right. So here's the sentence of the court. I'm going to put you on probation for 1 year, simply because I want to make sure that you stay on the straight and narrow. After 6 months, you will be allowed to ask the court for permission to get off of probation. But that assumes that you've got everything done that you need to get done. All right. The probation will cost you $360. There's a $75 crime victim fee, a $50 justice assessment. I'm going to reduce the court costs to $100, local charge of $15, and a fine of $50. $290 plus $360 of the probation oversight fee. That's $650. You can pay that off over the course of your probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation officer. You must enroll in and successfully complete a treatment program. I'm going to ask that you get screened for substance abuse and follow their recommendations. And your attorney, Mr. Dick, can assist you with where to go to get that assessment done. That'll cost you a few dollars to do that. But instead of trying to figure out what you need on your own, I want to have a professional tell you, all right, here's what you need to do, whether that's a alcohol highway safety class or whether that's a victim impact panel, whether that's inpatient, whether that's AA, I don't know. But I want an expert to tell me that, and then you follow that recommendation.
Okay.
I'm also going to ask you to be screened for anger management by a person with some counselor credentials, and follow the recommendations. Again, there may not be any anger issues that you have to deal with. There may be whatever the counselor recommends is what you're going to need to do, and follow that recommendation so that you don't have this problem in the future. And those are the two big things that I want you to do while you're having contact with your family. So that's kind of what I'm saying. If you're going to have contact with your family, you've got to do these things and follow these recommendations. And if you don't, I'm just going to pull your ability to see your family.
I understand.
All right. Because you've had problems with alcohol in the past, I'm going to say no consumption or possession of alcohol or drugs. No entrance into a business where alcohol is served by the glass. That means you can go into a restaurant that happens to serve alcohol. You may not consume it. You may not sit in the bar, but you may not go into a bar just because it happens to serve food. You understand the difference between those two?
Yes.
All right. I'm not going to put you in jail because you're on 769.4A. I'm not going to give you work camp because you're on 769.4A. But those two things are on the table if you mess up. You understand?
I understand.
All right. Do you have any questions for me as to what's required of you?
I do not believe so, no, sir.
All right. Mr. Dick, any questions?
No, Your Honor. Thank you very much.
All right. That'll be the order of the court, sir. You'll need to contact the probation department. You can reach them at the following number, 989-731-0215, and they'll assist you if you don't know where to go for substance abuse and anger management. Mr. Dick may also be able to assist you with that. And then they'll also assist you with getting started on your probation and paying off your fines and costs. All right, sir?
Thank you very much. I appreciate
All
it.
right. I'm going to just make a note that the bond condition of no contact is lifted. You may have
no drug.
Yep. What about it?
Does that include marijuana by chance?
It does.
Okay.
I don't want you substituting one controlled substance for another. If you're going to have a problem with alcohol, I don't want you numbing yourself with marijuana. I want you to deal with whatever the underlying problems are. All right. If you've got issues that you can't accept reality, I want you to deal with it so that you can accept reality. Your son needs you present, and needs you at full working capacity. You understand that?
Yeah.
All right. So you may have immediate contact with the victim. That's Ms. Murphy. Emma Murphy. All right.
Yes. Yes.
You've been given a gift here. Don't mess it up.
Oh, I won't, sir. I won't. I appreciate you, sir.
That's all for today then. Thank you. Good luck to you.
David Keeler Maldonado.
Yes, sir. We're ready.
Okay. What are we doing on him?
It's students and
Keeler Maldonado, is that you, sir? Come on.
what?
I really want to have a 12, but you said it kind of.
I think we fled it. In fact, I'm almost positive we did.
He's already pleaded guilty.
Yeah, I think it was reset because there was some risk and we reset, but it was only like a few days.
Any flex, we could do that without it. Is there another case that he's supposed to plead?
Mr. Boyd, are you on this one?
Yes, Your Honor.
I believe Mr. Laird took the plea. No, Mr. Ham, I'm sorry.
What's your final answer, David? What's your final answer?
How many choices? And I believe it was Mr. Ham.
We now call 24 CR 2392, the state of Texas versus Keeler Ivan Maldonado. That is you, sir? Sir. Present with your attorney, Mr. Grove, and the state's attorney. Earlier, you pleaded guilty to the first-degree felony of aggravated robbery. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
None from the
State.
state, Your Honor.
Well, what about?
Your Honor, I reviewed the report with Mr. Maldonado, and the defense has no changes to make to the report.
Then the pre-sentence report is made a part of the record for all purposes. The agreement is whatever sentence shall not exceed a cap of 12 years in prison. So we are looking at no less than 5, no more than 12 years imprisonment. Regular probation is not an option because a deadly weapon firearm was used in the commission of the offense, which gives the only other option to be deferred or unadjudicated probation, which can be up to 10 years in length. I think those are the 2 options, correct, everybody?
That's correct.
That's correct, Your Honor.
All right. Go ahead, Mr. Grove, on behalf of the defense.
I'm going to be very brief, Judge. I believe that this is a very unfortunate thing that Mr. Maldonado was involved in.
Certainly was unfortunate for the victim.
Well, and it's unfortunate for Mr. Maldonado and the other folks that were there because there were a number of other people that were at least present. But I think based on Mr. Maldonado's past, and when I say his past, that's the lack of a past where he has had no prior felony convictions. He has been very good as far as things goes until this deal here. And this was not in any way justifiable, but I believe Mr. Maldonado realizes that this could have been the biggest mistake of his life and that he isn't going to let it happen again. He also dropped out of school before he got his high school diploma. And I believe he realizes how important that is. At the time when this occurred, he was employed for the city of Port Arthur. So he was working at the time, but this is just very regrettable. And I believe that he realizes that. And if the court were to grant him deferred adjudication, I believe that would be in the best interest of everyone involved. And I ask for the court to do that, grant him a deferred adjudication.
State, what do you want to say?
Your Honor, obviously it's a very serious offense. However, it does appear from the facts and reading it that the defendant is not the one who actually pointed the weapon at the victim in this case. Obviously, we know that doesn't absolve him from that, but it does appear he doesn't have any other history. I don't think we would necessarily, in this case, be opposed to a deferred, but obviously, in the court's discretion, this did involve robbing a young man at a park that had pulled a gun out on him. And I believe after he told him, no, I'm not, going to give you my chain or whatever, they ended up leaving at that point after initially threatening him. And they were found shortly later in a parking lot, and there was a gun in that vehicle.
I believe that's true. There was no restitution, Judge, although if there was, it certainly we would be willing to pay that, but I don't believe there was any loss.
Y'all read the pre-sentence report and the probable cause affidavit? It's completely different from what you're telling me. He was the one that came out with the rifle. He's the one that pointed the gun at the chest of the person. The others were all juveniles. He was the only adult in the group. That's what's clear in the pre-sentence report. And that's what's clear in the probable cause affidavit. Maldonado approached Contreras, demanded him to give him 2 necklaces that were worn by Contreras. During the time, Maldonado pressed the muzzle of the rifle up to the victim's chest, but he still refused to give him his property. After that, several other subjects in the gang of thieves exited his vehicle and came up to the lone victim who was helpless and demanded and threatened him to give up the necklaces. He still refused. Then the defendant and the others left. He was the only adult in the group. The other 4 juveniles are being processed as juveniles. Now, his version. I was with some other people. We stopped at a park. We saw this guy. We robbed him. They passed me the gun. I just went along with this, even though I didn't want to. So much for taking full responsibility. That doesn't help him. He can't even tell me the truth. He can't even tell the truth. At this stage, when he's got everything to lose by not telling the truth. All right.
Yes, sir. I would point out that he did
12 years in prison. You know, if I sentence you to 12 years in prison, you can't get out until 50% of it is served at least. You'd have to be there for at least 6 years. Do you understand that? You want to tell me the truth about what happened now, or are you going to continue to lie?
Sir, like I said.
I'm sorry.
Sir, I'm not lying, sir. Like I said, we went to the park.
Who stuck the gun in his chest, sir?
Who, me, sir? I had
All right. It's not what everybody's saying here. You were the oldest in the group, weren't you?
Yes, sir, I was.
Well, you know, had you fired the gun into his chest and killed him, there'd only be 2 choices. The death penalty or life without parole. Those would have been the only options under law. Really? You thought this was a wise idea? Why'd you pick on that guy?
Wasn't, sir.
Sir? Why'd you pick on? Was he just the most helpless person you could find?
No, sir.
The most vulnerable person?
Yes, sir.
What?
I don't know. It's just wasn't.
Anything else?
No.
I'm still a little unclear about the state. What's the state asking for?
Your Honor, them not having the history, obviously it's very serious, would defer to the court, although I don't know that we would be opposed to the deferred in this, where he'd be facing obviously the maximum range of punishment if he decides to screw up at any point in this.
Anything else? Anybody just say?
Yes, certainly with the regular probation being eliminated by the state, by the law, not by the prosecutor. If Mr. Maldonado does screw up, the court has a much wider range of things he do. I think this will be the last time the court will see Mr. Maldonado. I think his background, although he has not been perfect, and in this case, there's no doubt that this is not justified. Mm-hmm. I believe that for whatever reason, he decided to do this before he had any other criminal history. And he wants to make a success of his life, and will be able to do so. And if he doesn't, then he's looking at 20 years in prison that the court could sentence him to.
How's that?
It'd be 5 to 99 or life.
How's that?
Oh, I'm sorry. I'm sorry. 5 or 99. The court could be looking at giving him 99. I apologize. I was thinking it was second degree, but it's not. It's at first degree. He could get up to life in prison if the court decides to go ahead and revoke his probation.
Do you have any family here?
My parents.
Your parents?
Yes, sir.
And they did it all here at Judge and their present. And I apologize.
Where
I
did the
didn't-
guns come from? Where did the rifle come from?
It wasn't mine, sir.
I'm going to ask you one more time. That wasn't the answer to the question. Because the answers you've already given haven't been truthful up to now to the probation office or to us.
Came from a friend, sir.
Who?
The woman, people.
What's the friend's name? They got a name? It's a friend. You know the name. I know all my friends' names. What's the friend's name? Don't look at him. Look at me. When you do that, that means you're trying to lie.
Daniel.
Huh?
Daniel, I think.
What's his last name?
I'm not sure.
No. How long have you known your friend?
I met him for like 2 months, maybe.
Where'd you meet him?
Off of another friend.
2 months ago?
Like 2 months I had met him.
I don't understand what you're trying to say.
No,
2
like,
months ago?
No, not 2 months ago. Like I had knew him for like 2 months.
Oh, when this had happened?
Yeah, like
When this event happened?
Yes, sir.
Where did you meet him?
Where did I meet him?
I asked you first.
Off of another friend. Like I met that friend off of another friend. It makes sense.
So how did this firearm thing come up? How did that?
We was all together at first. Like we was just together, and then we had went to the park.
Well, why were you selected to stick the rifle in the child's chest?
Sure, sir.
I wasn't there. You were there. You know what happened.
Yes, sir.
Think about it while you make up a story.
Just,
okay. Anything else?
No.
All right. The agreement is a cap of 12 years. That's the most you can receive. 12 years in prison, no less than 5 nor more than 12 years confinement in prison. Do you understand?
Yes, sir.
All right. The court has reviewed this fully and has read the pre-sentence report and have you ever used drugs before?
Before, yes, sir.
Mm-hmm. When?
I would say like around my 16 to 17.
You were 17 when this happened, right?
Yes.
You were almost 18.
Yes, sir.
Is that right? Or
yes, sir. Thanks.
no, you had turned 18 by 1 month. Your date of birth is October 6th,
yes,
right? Of 06?
Yes, sir.
Okay, this happened November 2nd, 24. So you would have just turned 18, right?
Yes, sir.
Anything else?
Nothing, State Your Honor.
Here's what I'm going to do. The cap is 12 years. Stand by. Joe, coffee went up in price today.
Seems like I heard something. Coffee's gone up so much. Just about care last.
I can pay it off in a few years, Ron.
It's going to take that long. You drank all the coffee in your last trial. That's we ordered. Come on up here. All right. All right. You don't want to be in there, do you? 6 years at least in prison. And you were in there by yourself. I mean, they got far more meaner people in the prison facility than you can ever imagine. Live with them for 6 years. Good luck. All right. This is a terrible thing you did. You should know, you know better, and shame on you for that. I'm going to find you have pleaded guilty voluntarily. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty.
Yes, sir.
There's sufficient evidence from State's Exhibit 1 admitted at your plea hearing to support your guilty plea to find you guilty beyond a reasonable doubt here. However, the court is going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. You better do well. Everything is writing on that. If you fail to complete and follow the terms of your probation can be revoked. I can then find you guilty, and then you can be sentenced up to life imprisonment.
Yes, sir.
You understand? All right. Now, how far did you go in school? You didn't graduate. You're going to complete an educational program for high school equivalency, GED. There will be terms and conditions of probation, such as completing a moral reclamation therapy program. That is a program that helps you understand and appreciate when you victimize people. You just don't walk away from it. You have to empathize with the people you harm and try to help fix the mess that you make. This is all about growing up and being responsible. You should have known this at your age, that sticking the gun in somebody's chest and stealing stuff from them is serious. You have the control and the power, not them. And that's not the way the Creator meant it to be. You're not supposed to take advantage of people. You will have no contact with the victim or anyone on behalf of the victim, such as family members. And that is by telephone, social media, through a third party. You will avoid all association with the co-defendants in this case, the 4 others. There are 31 conditions here, but most of those are the requirements all of us have to follow. Don't commit crimes. You will have a curfew. You're going to act responsibly, or else you pay a serious price. You also can't stick a rifle in somebody's chest, threaten their life, and steal. You're going to go to jail for a little while. I can place you in jail for up to 180 days. Do you go to school? What grade did you complete? Did you complete high school?
11th grade, 10th grade, dropped out.
Why?
Just wanted to start working.
Did your parents condone that? You know what that means, condone, approve of that?
Approve of that? No, sir.
So you went against their wishes?
Just didn't want to go to school.
Yeah, well, you guess what? You're going to go to school. Like it or not, you're going to get an education. It makes you make wise choices. You can see the foolish choices you've made while you haven't been going to school. Education is a wise thing. I made that up, but it sounds like it was the right thing to say. But it helps you make better choices. You're going to complete your high school education as a condition of this, like it or not. I mean, how I have to force somebody, threatening them with life imprisonment to complete your high school education sounds like a Twilight Zone episode. It just doesn't make any sense. It's off the grid. But this is conventional behavior that works. All right. You're going to have to do 180 days, and I will decide when you've had enough. You will do this on weekends. You will check in on or before 6:00 p.m. on Friday. They will release you Sunday. You will go to school during the week when you get into school, and that has to be done at the earliest possible time. You will attend school and complete your high school education. You will act responsibly. That's what all of these conditions are all about. Once again, if you fail, you're looking at life imprisonment. And all of those, every one of those conditions help you be a better person. Why you would work against that defies logic. But start acting, with intelligent thought, and school will help you, and also the probation office will help you. We have a 93% success rate, which is far higher than the national average. That's because we know what we're doing. We help people fix their problems, except for the 1 in 14 who don't. All right. Anything else to add? Did you have any questions for me from parties?
None from the
Please
state.
see the probation officer
Starting weekends today or next week?
next weekend. That begins next Friday. Don't get in any trouble in the jail.
Yes, sir.
I find out on Mondays when people file up who are on my watch. And that would be a term of probation violation. Okay, do you understand? Oh. Please see the probation officer. Thank you. Okay, Jeremy Dixon.
It's a motion for new trial. Very good.
You dropped the whole thing together.
We now recall 23 CR 1222, the state of Texas versus Jeremy Dixon. And the defendant is present with Mr. Vasquez, his attorney. There was a motion for new trial that had been filed earlier by the defense. Okay, the court has signed an order denying the motion to for a new trial in this case. You've asked for a hearing. Go ahead. Did you want to add anything?
No, Your Honor, I stand by the motion. Just the appearance of impropriety. I realize it doesn't meet any of the criteria listed in the motion for new trial.
All right. The court stands, nothing further. The court stands by the order that it rendered on August 25th. The motion for new trial is denied. What else? Anything else on that?
No,
Thank you. That is all. It's denied.
The court just denied.
You'll get more of that in the order.
Thank you.
Here.
Leo Cover. Leo Cover. Leo Cover. Come on up. And we're back. Leo, you got these two cases and we are going to move to trial. That's what you want still, right?
Yes.
Yes, sir. Okay. Y'all haven't been able, he's representing himself and you're going to continue to do that, correct? That's what you want. All right. When we've talked about it, I think ad nauseum about the pros and cons. You've thought about it. You seem like a smart guy. You've decided this is what you want and you know the pros and the cons. You still intend to represent yourself.
Sure.
Okay. We've got two cases here. One is a state jail felony of publishing or threatening to publish intimate matter. And the other is a state jail felony of theft. Now, let me ask, Mr. Cover has served almost 2 years in jail. 22, between 22 and 23 months. Is that the most he can get is a state jail felony?
Your Honor, what this priors is actually can be up to, he can be in.
Okay, help me out. I don't see the priors aren't.
They're not this indictment. They're not in this indictment, but he does have prior felony convictions.
Was he going to get notice? Is he going to get notice of that?
It's in the file.
Thank you, ma'am. What kind of, it's not in the indictment. Where is it in the file? Where have you received notice from them that they intend to present?
I got one that was from last year, but then it's been amended since, and I haven't seen it. At least that's what's on the computer. Looked up.
I believe I filed before. I'm sorry. I believe that was when Mr. Kimmler was representing him. I believe it. But Your Honor, I believe I did file. I'll look, pull it up real quick. When Mr. Kimmler was representing him, I believe I filed the notice of intent to seek enhanced punishment.
Okay, is that the amended
No.
one? That's what he needs the most updated.
Yes, sir.
Can you get a copy real quick? Did you want? I don't know. Let me check.
No.
So I can see what you're looking. I don't even know what it is. All I see is state jail felony.
Correct.
But if you have prior convictions and they give you notice,
that's for the punishment.
It could be, the punishment could
But
be up to
it's a state jail
it could
felony.
be up to second degree felony, depending upon what it states. All right, here's a first amended motion. All right. Notice. Here, give this to Mr. Kelly. I handed this to you, Leo. All right, it states that you were finally convicted of burglary of a vehicle in 1980 in the 179th District Court of Harris County, Texas. I think that was a third degree felony back then.
Yes, correct, Your Honor.
It's not now, but if it is, then
I'm not even arguing any of the convictions.
I understand, but then next is that you were finally convicted of illegal possession of controlled substance in 1980. And before, in a different cause number, then it states you were finally convicted of aggravated robbery out of Montgomery County in 83. You were also convicted of another aggravated robbery in 1987 out of Sabine County. And in 1993, convicted of retaliation out of Sabine County District Court. So, each of those could, if one or more are true, or two or more are true, then those could enhance your punishment from a state jail felony punishment to a third degree felony punishment. But then you've got those last two paragraphs that state that after those convictions were final and before you committed this new offense, you were finally convicted
And it would just bring it to a second degree, Your Honor. Just their
what was the conviction?
If I'm mistaken.
What's the subsequent? Hold on, everybody. Let me talk. Let me talk.
Yes, sir.
When I speak, everybody stops so she can take down, because she can't take down everything if we're all talking at once. What is the most recent conviction after those others we've talked about? Is it the aggravated robbery in 96?
Yes.
Okay. And then also escape in 96. Right?
That's correct.
That's what this is showing. Okay. So those two are in sequence of the prior three. The 5 prior convictions. And if all of this was true and you were convicted, then your punishment range then becomes second degree felony punishment range, up to 20 years in prison. Okay. But you've got a copy of that.
I don't think that's correct.
They've got to prove it as alleged.
I mean, it says.
I know, but it's not.
It says aggravated.
Yeah, but it's, this isn't a debate here. It's what they put that in to give you notice. They better prove it, or else it's not adequate.
First, I have to be found guilty.
Yeah.
And I don't think that's going to happen.
Okay. You want to represent yourself?
Yes,
okay.
I do.
And you've thought about it long and hard, and this is have you ever represented yourself before in a trial?
Yes, sir.
Okay. Well, you know that the judge expects you to know the rules of evidence and holds you to it, and the code of criminal procedure and the penal code. Okay. And these guys went to law school, and that's what they do for a living. You can represent yourself, but it's always been for the most part, it's been difficult for defendants to represent themselves against people like this. But you understand that, and you wish to move forward. How many witnesses do you intend to call?
Your Honor, there's only, I believe, four or five at most.
When can we put this in for trial?
Judge, I have a special set on November the 4th.
Well,
3rd.
And Your Honor, we're trying to make sure Mr. Cover is allowed to go through all of his discovery on this, which I do have it tabbed out, and we're allowing him to see some of it, but there's a large volume of the electronic data on here that we're allowing him to go through. I think we're going to schedule it, I believe, for next week. We're going to schedule
Next week.
a day for him to come back and review it in the jury room back there again.
It's over 5,000 pages. It's going to take a minute.
Yeah, I know. Take as long as you need.
And my motions that I filed, I haven't had motion hearings.
Yeah, go over them. Which ones do you want to ask? What are you asking for relief for?
I'm asking because of delay of trial, speedy trial. I've been trying to get a speedy trial. I haven't got it. I'd like to know about if the indictments. I don't even think I think I got a rubber stamp indictment. I don't think I haven't had a motion hearing. I haven't had discovery. I've been filing my motions. I haven't had any.
What
motions
motions are you asking for?
Nobody else is.
You look at your motions. You asked me what motions. You're the ones that filed it. Get it before me. Come on. Yeah.
I want to hear the pro se motion for the writ habeas corpus. Habeas corpus.
What do you want to add? What do you want to add to that motion? What do you want to add other than what you put in the four corners?
Hear the motions heard, and I want to hear the order.
No, what additional evidence do you want to add to it, sir?
Oh, I don't need any.
Then it's overruled. I've looked at it. Unless you have something different than what you put in the four corners, it's overruled.
Okay.
But it's preserved for error. But it's a preserved error.
What about the motion for the question set aside the indictment?
That is denied.
Okay, am I gonna get a written order on any of this, or are you just gonna deny every one of them?
We're putting the order into the record, and if you want a copy, we can make that
I want a
later.
copy of all of it.
Are you gonna interrupt me, Leo? Come
I
on.
haven't got a
Leo,
copy of his
wait,
amended
hold on. Sir,
briefs. I
sir.
haven't got copies of nothing.
Sir, when the court speaks, you need to stop. You're gonna get a fair opportunity to speak.
It's not always fair. You're denying
Leo,
everything I do.
We've done this once again.
How the hell is
Leo,
that fair?
when you shout over the court, she cannot do her job and you get, and that's improper. She's got to take down everything. Leo, you may not like what's going on here, but please follow the
Well, you
rules.
tell
And
me
if
to
you
follow
have
the
a
rules,
right.
and you're not. You just sit there and deny.
I've read it, sir. I have read this whole file, sir. You don't know. Are you clairvoyant?
Yes, I am.
All right, that is all. We'll set it. It's gonna, we'll see you at trial. Thank you, Leo. You can't be calling people names and speaking over people. It's rude, Leo. You know that. All right. Okay, Cameron Smith.
That's probably for you. No, both of them, that's just I have one. Yes. Seriously. Yeah. Okay. Be a chance to see. Just ask me. On one, I'll go to the sure. Not necessary. I can't remember. So pretty good. I'm gonna be through the last 3 weeks. There's somebody, we did week off, I'll be there for a couple of weeks.
Okay. Y'all are gonna have to refresh my memory on this.
Yes, sir. This is the case we pled a while back.
Did he abscond? Before sentencing?
Yes and no. Okay. He absconded. He didn't come back for sentencing, but it wasn't his choice. He got arrested and was in Harris County Jail. So that's why he didn't show up for sentencing, is because he couldn't. He was incarcerated at the time.
What happened?
That case was eventually resolved. It was dismissed, dropped to a misdemeanor. He got credit for time served, and then released, and then it's over here now with us to finish this up. It's been resolved over there now, but that's why he was not available when we originally had our original sentence date.
Okay.
So like I said, yes, it was absconsion, but it wasn't voluntary.
It appears as though he entered his pleas in cause numbers 23 CR 2000, third degree felony of deadly conduct, discharge of a firearm, and 23 CR 2001, the second degree felony of aggravated assault with a deadly weapon. These occurring, it looked like, on or about the same date. And shooting at a vehicle and knowingly or recklessly causing bodily injury to another person. So shot at a fire, and he shot fire at a vehicle that was occupied, and somebody in the vehicle was injured.
That's correct, Your Honor.
Okay. And that's the second degree felony of aggravated assault, carved out 2 crimes out of 1 episode.
Yes, Your Honor. There was I apologize, Your Honor. I was gonna get the court kind of breakdown of it if you would like, but
okay. The defendant entered these pleas of guilty to these offenses on December 9th, 2024. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? And are there any corrections or changes to it?
No,
State?
none from the state
or defense?
Same, Your Honor. We've reviewed it. There's no corrections.
Then without objection, it will be part of the record. The agreement is whatever sentence shall not exceed a cap of 7 years in each case.
Yes, sir.
So we're looking at 2 options, really.
Yes.
No less than 2, no more than 7 years confinement in prison for each case. Or deferred or unadjudicated probation. Regular probation, is it agreed upon, is not an option because a deadly weapon, namely a firearm, was used in the commission of these offenses.
That's
correct.
Okay. All right. Go ahead.
Your Honor, I do have a letter that my client has prepared for you if you want. It is evidence or have him read it whatever way it's best.
Whatever you want to do.
Do you want to read it or you want to? Okay, we get that point. Hold on a second. We'll wait to get to one. So like me to go first or the state?
And again, you are Cameron Jace Smith.
Yes,
And then Mr. West is here representing you and the state's attorney is here. So, okay, go ahead.
Your Honor, we are going to be requesting the probation, the deferred probation, in the sense that this is my client. He doesn't have any prior convictions, or felony convictions. This was an unfortunate incident. I'm not going to even justify that. It's unjustifiable, but it was a mistake he made, a horrible mistake he made. But I think he has been remorseful since then. He has a letter that he's written kind of talk about that. I would like to call him as a witness, have him explain some stuff to you. So you can
Raise your right hand. You solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Lower your hand. Thank you.
Thank you, Your Honor. Mr. Smith, go ahead and for now, you've written a letter to the court. Is that correct?
Yes, sir.
Go ahead and read it into the record so the court understands kind of your position. I think it's better than you just speaking. Go ahead.
While being incarcerated, I had time to think and reflect on my decisions and my choices. Something I have done to hold myself accountable. I'm not being noticed for making excuses for the way I'm doing my life. I can carry blame on this and that person or this person, but ultimately, it starts with me and the people I surround myself with. I'm at a point in life where I'm becoming a man, and I'm learning about myself every day. You know why? Your Honor, I want to give my sincere apologies to the court and the victim for my actions. I would like to ask the court to make a harmful decision when determining my eligibility for probation and take into account the positive momentum I have doing despite not having the proper guidance. All people need sometimes is one more chance to put the best foot forward, and to go. Please allow me to show you and my family and myself that I can be a functioning member of society and not a hopeless member.
Okay, and also you just told me something a moment ago when we were standing here, something that's happened since the last time we was work, which was just earlier this week. What's happened since earlier this week?
I just had a daughter 2 days ago.
Okay, so is this your first child or how many children do you have?
2 kids.
Okay, this is your second child? Okay, how old is your other child?
Mm.
And you've been in jail for how long right now?
Well, what's the date of birth of the child? What's the birthday of your child?
August 27, 2025.
His youngest one was just born 2 days ago.
August 27, 2025.
No, but he had another child.
Oh, what's the birthday of the other child? I'm sorry.
November 11, 2024.
Okay. All right. And you understand that doing the right thing is important for those kids, correct?
Yes, sir.
Okay. Setting an example for them is very important. Is that right?
Yes, sir.
Okay. And is it your hope to start living a good life if you get probation, doing the right thing?
Yes, sir.
Okay. Now let's talk about the thing over in Houston because I know that's an issue. You did not show up for our last sentencing date. Is that correct?
Yes, sir.
Okay. Where were you?
Harris County.
Okay. All right. Harris County Jail, correct?
Yes, sir.
Okay. You had some charges over there, right?
Yes, sir.
Those charges have since been resolved. Is that correct?
Yes, sir.
You ended up getting credit for time served misdemeanor. Is that correct?
Yes, sir.
Okay. And then they released you and you came straight from Harris County to Jefferson County?
Yes, sir.
Okay. So since being locked up in Harris County before the sentencing, you have been incarcerated the entire time?
Yes, sir.
Okay. So you didn't miss court because you didn't want to show up, right? Okay. It was because you were
incarcerated,
unavailable, correct?
Yes, sir.
Okay. And you're asking the court to grant you a chance on probation, is that right?
Yes, sir.
Okay. Do you think you can do probation?
Yes, sir.
Okay. You got any work lined up or something you can do, or what are you gonna plan on doing?
Yes, sir.
Okay.
I'm ready to go back to work and take care of my kids.
Okay. Go back to work. What were you doing before then?
I work in Home Depot.
Okay. And can you go back to Home Depot?
Yes.
Okay. Do you know if that job's still there, or you just think you can probably get that job?
I still get the job.
Okay. Okay. How much were you making at Home Depot?
$8 an hour.
Okay. All right. And you expect to go back making that same kind of pay?
Yes, sir.
Home Depot here or Brockville where? In Houston. Okay. All right. Home Depot in Houston. Okay. So you can satisfy the requirements of probation if you're given the chance.
Yes, sir.
Okay. Stay out of trouble.
Yes, sir.
Make your payments.
Yes, sir.
Do your community service.
Sir.
That's the way to try.
Mr. Smith, on October 22nd, 2023, who were you there at that apartment complex with there, the Hamlet Park Apartments?
My cousin.
And who's that?
Cameron Boone.
Were you also with an individual by the name of Victor Green?
No, sir.
And just prior, what kind of did you have a gun on you that day?
Sure.
What kind of gun? Was it a handgun or a long gun? Did Cameron have a gun on him?
No, sir.
Who was walking with you towards this black Mercedes just before the shooting there?
I don't remember their names. No, sir.
Did that individual have a gun?
No, sir.
So you're the only one who had a weapon there?
Yes, sir.
Well, hold on. How did you come to know that person who's unnamed, that you don't know, whose name you don't know, but yet you're involved in shooting with some people in the car, and you're with somebody and you don't even know their name? Who's that, and how did that happen?
It was just,
You have to speak up
yes,
so
sir.
she can hear.
It was me being with my cousin, and I was with one of his friends, but I don't like know his real name. Well, I just met him that day. So me just being with him, me being in the office for a long time.
Okay. Go ahead. So the other individual that's were you ever walking towards this black Mercedes vehicle?
No, sir.
How did how did you start shooting?
Because the Mercedes pulled behind me and started shooting at us first.
I have no further questions, Your Honor.
Real quick, I just don't want to clear something up, Your Honor. I think that it's clear, but I want to make sure. This other individual that you don't know, it was a friend of your cousin's, correct? So you were there with your cousin.
Yes, sir.
Okay. So you just met this person that day.
Yes, sir.
Okay. Not a friend of yours, not a relative of yours, or you had no contact except for the fact that he was your friend of your cousin. All right, pass on this. Nothing more.
Nothing further. No other question.
So, where'd you get your firearm that you were shooting at the car with? Think about it.
From Frank Houston.
Who?
Um,
He's a friend of yours. You don't know his name?
his name is Josh Moore. Josh Moore
Where does he live?
in Houston.
Look, I know 2 million people are in Houston. Where in Houston does he live?
From Southwest Houston.
Okay, so why did you have a firearm with you? At 19, you're 19 years of age when this happened, right?
Yes, sir.
Yeah, what are you doing carrying around a firearm shooting at cars? Is it something to do in Beaumont?
No, sir.
Oh,
I don't think it was a good decision either.
I looked at all the paperwork here, and we found all kind of guns where he was hiding: a rifle, handgun, shell casing. Who had the rifle? Y'all had a rifle. Who had that?
That's the when the Mercedes started shooting at me first. You know what I mean?
Your Honor, what the witnesses described in the Mercedes and a witness who was nearby described two individuals walking towards that black Mercedes with weapons out, which one of them was a handgun, which we believe is Mr. Smith, as well as the other individual had a long gun.
Is that right?
No, sir.
Nobody had a long gun?
The only two people that had long guns, the two people that came out the Mercedes shooting at us. You know.
I'm sorry, but you had a gun.
Yes, sir.
And Your Honor, the witnesses who were in the Mercedes said that they pulled near a dumpster turnaround there, which one of the individuals in there lived at those apartments, and they saw Mr. Smith, as well as a Victor Green, who had formerly dated one of the individuals in the car, walking towards them with guns. The two males in the back of that black Mercedes jumped out with guns as well, which were long guns. And they said that
Who's
both,
they?
I'm sorry, it was Faith Simon as well as the complainant here, Jayla Charlotte. They were in the vehicle along with a Daniel Harvey Jr. and a Joshua Slaughter. So the two females, Miss Charlotte, Miss Simon stated that both Joshua Slaughter, and Daniel Harvey Jr., upon seeing these individuals walking towards them with guns, jumped out with their own guns. And they described the individuals walking towards them, started firing, and shortly after, they returned fire. They were the ones who contacted the police. The other individuals that were there, it wasn't Mr. Smith nor Mr. Green who were involved in that. And they found police found Mr. Smith hiding there in the little fenced-in area of one of the apartments right there, and there was a handgun hidden in the I believe the barbecue pit right there, 9mm. There were also several apartments that were hit, Your Honor, with stray bullets. No one there in the apartment complex was injured, but there's also a nearby home that was struck with the bullets. So it was
Damage.
quite dangerous. Yes, Your Honor.
Okay. What are you asking for?
Your Honor, I believe
I see what I see what the deal is.
Yes,
What are you asking for? I would just say.
I believe the 7 years is appropriate. There was by going ahead and taking it upon itself to then start firing first and create this situation that could have killed or injured lots of people there at the apartment complex. Your Honor, I believe that warrants that kind of activity, and doing those things warrants every bit of the 7 years. They actually, took a step further rather than just having the gun. They went there and started firing, and could have injured not only the individuals in the car more severely, they also everyone around, kids, people living there. Yes, Your Honor.
Okay. So I just want to get this clear. Why were you shooting at? What's your final answer here? Why were you shooting at the God bless you at the car?
No. I didn't shoot at the people jumped out with the sword. What they saying, I don't want to put the blame on nobody else. But I know I'm in the wrong for being there, and I'm taking accountability of my actions.
No, look, you're charged with deadly conduct. Right. That's discharging a firearm in each of these cases at people without good cause. Why were you firing the gun?
Because two people, I'm walking in the apartment.
Why did you shoot the gun?
And two people get out the car and get to shooting at me.
First?
Yes,
He was
shooting me first.
Okay. We'll set this for trial. He just admitted he's acting in self-defense. He is not admitting culpability to this. We're going to put this in trial and try these cases. I don't accept the deal when you're looking at me and telling me that you're doing it in self-defense. That's not accepting responsibility. Here, it's set for trial. That deal is off. Now we'll let a jury decide each of those. All right. What else? Did you get, are you working on Fowler?
I got him to sign this stuff up.
All right. What else do we have? This. Well, that's one way to talk yourself out of the deal. Wonderful weekend, all of you.